Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Welcome back. This is Ken Landau, and we're talking with Richard Solomon. He's an attorney and also the author of the book, Winning in the New York Small Claims Courts. And it's available at many bookstores, such as Barnes & Noble and local bookstores. And there's also a website. You can obtain information at smallclaimsbook.com. Richard, you've told us about the types of cases you can bring, how you follow with the court. Sometimes you may have a choice. A person might be able to complain to the Better Business Bureau, the Consumer Affairs, to Department of Motor Vehicles, to some state agency if they're owed back wages. But there's nothing stopping them from also going to small claims court or going to small claims court if those other remedies do not work.
Actually, the small claims court is probably the most effective because that's where you'll have very swift justice. A decision will be rendered pretty quickly, and it has the force of the law behind it. So if you obtain a judgment, you can hire the sheriff in the county that you're seeking to collect the money and have that enforced, whereas other places like the Better Business Bureau can only tally opinions.
And as long as the claim is under $5,000, there's almost any type of claim you could bring in the small claims court.
That's correct.
Okay.
But you can only ask for money.
Only ask for money. You can't throw someone out of a house.
No injunctive relief.
Okay. So you've filed the complaint, and the court is serving it by certified mail, as you mentioned. What happens if it comes back with some problem with the service? The company's no longer there, or it's not served on the defendants.
First, double check to make sure that you serve the right address. Sometimes there are typos, and that's easily corrected. One of the things that's great about doing your research up front is if you had used a check, letterhead, invoice, or the Department of State website to confirm the address, chances are that should be a good address. If it turns out that the complaint is bounced back, I would personally take a little ride to see what happened at the address, because if the company's out of business, it may not be worth pursuing any further. Businesses do out of business.
What if someone just ignores the certified mail?
That happens a lot, and that's strongly advised against. Every time you're sued, you must always put an answer. You must always either, if you feel that you owe the money, try to work out a very, very favorable deal, get long payment terms, and if you don't owe the money, then go to court and fight very hard for your rights.
Okay. It's coming up. You're successful with your service questions, and you want to do a little more work. You want to make an outline or the points you want to make, the questions you want to ask, because you may be questioning them, they may be questioning you about the claim. What should you do to prepare for your session in court?
What I always tell all the people who go to small claims court is to create 3 loose leaf binders. Go to an office supply store and obtain 3 loose leaf binders. And then in chronological order, put in all the documents that you're going to talk about in the case. And you'll number them 1, 2, 3, 4, etc. And you'll have 1 binder for yourself, 1 for your adversary, and 1 for the court. When you go in this fashion, you're organized, everything's in order, and you're going to speak from the documents in chronological order, and you can establish a baseline of how the relationship with the other party started, how it proceeded, and what went wrong, and why it went wrong, and what needs to be done to fix it.
And if the matter is somewhat complicated, what do you think it's worthwhile for a person to have a brief consultation with an attorney just to go over the law that might apply, the proof they have to amass at the court session?
Absolutely. Sometimes your small claims court case may have implications in another case. So what I tell people is if it's really important, consult an attorney, and if it's essential, bring an attorney with you. You can bring an attorney with you to small claims court.
And that works for both sides. If you're being sued, you can bring an attorney with you. Sometimes your insurance company, if you're being sued over a property damage matter, your insurance company might provide a free attorney to defend you.
And that would be the best thing.
In fact, you should notify them so that you can invoke whatever insurance coverage you might have. You come to the court. What should you do if someone asks for an adjournment?
Generally, the court is very liberal about granting adjournments, especially at the first time. One of the things that the court does not allow is adjournments by phone or by letter. You must personally ask the court, and the term of art to use is, you say, application, because you're applying for an adjournment. The court will ask, what is the nature of the application? I need a witness. I don't have all my documents. I'm waiting for something to come in. and be guided by what you need in order to ask for a proper date so you don't have to ask for another adjournment.
Okay, and you also may be given a choice as to whether you want your case heard by a judge or arbitrator. Explain to us the difference and what do you recommend?
Most courts have only one judge, but they have several volunteer attorneys who are called arbitrators, but they're not really arbitrators. They're people who decide cases on behalf of the court, and their decisions are binding, and you cannot appeal from that decision. What's great about going to an arbitrator is that your case is over that night. And if your case is heard and you've done your best shot, you can move on and you can be finished. On the other hand, if something's very, very important and your case is super technical and requires a lot of evidence and whether things are admissible into evidence, you may want a judge, especially because a judge's ruling can be appealed, whereas it cannot be appealed when it's an arbitrator's decision.
Okay, and under some circumstances, the defendant can ask for a jury trial?
That's correct, although the idea of small claims court is that it's a very informal system, and I'm actually surprised when people do ask for jury trials.
I mean, this is almost like the court people see on TV, like Judge Judy or whatever the programs are now, where they're dealing with real issues that involve money, that involve testimony, involve some documents, and the judge is going to make a decision. You know, in small claims court, no judge is going to yell at you or put you on trial.
No, the TV is very, very different from real life.
But same types of cases, maybe not as crazy, but
not as dramatic. But there is an element of anger in a lot of the cases, and one of the things I tell people is really stick to the facts.
A person, if they've received estimates or reports, can they bring those reports? Let's say something was installed improperly. Can they get a letter or estimate from a second person? They have to bring the person there live?
The best evidence in the world is to have live witnesses. And one of the rules about evidence is that you're supposed to bring evidence that is subject to cross-examination, which we know as hearsay. You cannot just bring a document in to prove the truth of what's in the document, but you can bring in certain things like estimates to show a range of a high or a low or things like that.
If you need witnesses, maybe a witness to the accident, a witness to whatever took place, you should try to bring them as well, a live body?
Oh, absolutely. In fact, one of the things I tell people is to leave a camera in their car so that if you're in a car accident and there are damages, there's no better proof than you being the photographer that takes pictures contemporaneous with the accident.
But even if it's an issue about something else, if you have a picture to show a condition, a problem, and what an item looked like before and after, that's something you should bring in as well.
Oh, pictures are really worth 1,000 words.
If there's some documents you need from the defendants or from a third party, can you have them subpoenaed into court?
Absolutely. Although I tell people if you really need to subpoena evidence, try to avoid it if you can. I always tell people it's always better to have a great case. You should have all the documents you need. And sometimes if you obtain them before you sue, you won't need to subpoena them.
Okay, at the court, you're going to give your testimony. The judge may ask, or arbitrator may ask you questions. The other side has a right to cross-examine you, and you have a right to cross-examine them if they testify.
One of the best things that you can do is when the court says, what is this case about? If you're the person bringing the claim, known as the claimant or the plaintiff, is to give a 30-second summary of your case.
And should a person practice their case, in front of their family, in front of their friends, just to practice making that 30-second statement, to practice asking some of the questions, to practice giving some of the testimony?
Absolutely. And one of the best things they can do is they can write out a short opening statement on an index card and then try it out on friends and family. Because there's no problem in bringing notes and reading off of them or bringing a book or a text or a treatise in with you to aid you. As long as you feel comfortable, that confidence will show and will help you in court.
What other tips do you offer to someone at the court hearing?
Be organized. Never lie. Be flexible. A lot of times, defendants owe the money, but they just don't have the immediate means to pay. And if you get the signal from someone that they're looking for an extended payout plan, I say that a settlement is always a victory.
Okay, and in that light, should a person also be ready to compromise? The defendant doesn't admit it's quite their fault. You're not happy with the work that was done. You want to have it redone. Does it pay to compromise?
Absolutely. there's nothing better than a settlement because a settlement is certainty.
And also, you don't know exactly what the judge will do. You don't exactly know if you'll be able to enforce it. So at least the settlement gives you some certainty. It might be a win-win situation where everyone, or a lose-lose situation where everyone's not quite happy, but they can live with it.
Essentially, if you can come away from the experience feeling somewhat satisfied that your case was heard, you have some resolution, maybe it's not all the money you want or need, but it's sufficient, you should have a good feeling from that.
Okay, and in terms of enforcement, usually the judge is going to reserve decision, you'll get it a few weeks later, and what do you do to try to collect on any money?
It depends. If you've won, you'll be awarded what's called a judgment. It's a document that allows you to enforce your rights as a creditor. Generally, the other side has a small period of time, about a month, to pay on a judgment. And what you can do is you can hire a sheriff in the county in which the defendant resides to enforce the judgment. The best thing, of course, is to seize assets, liquid assets such as bank accounts, and I talk about that in the book. I actually talk about the step-by-step process of bank seizure because it's kind of technical. And
also there's some provisions for suspending licenses of drivers, and I think perhaps of even motor vehicle repair shops if they don't pay a judgment.
Well, one thing I know for sure is that if a judgment debtor, person who lost the trial, does not pay the judgment that's in excess of $1,000 and they were involved in a traffic incident and the damage was in excess of $1,000 and you're not paid, you can apply to the Department of Motor Vehicles to have the owner's registration of the offending vehicle suspended for non-payment of the judgment.
And if someone's confronted a situation where there's a judgment against them and for whatever reason they didn't know about the lawsuit or claim against them, they can go to a lawyer or perhaps on their own try to open up the default?
Yes. In fact, that's quite common. The term is called vacating or erasing a default judgment. And there's forms for that in the courthouse. You can go to the clerk and fill out what's called an order to show cause form. And it asks the court to open up the case so that the case can be heard by the merits.
And the important thing is they not ignore it, not let any more time go by. They do something about it. They can always consult a lawyer about it or go down to the courthouse that issued it.
Absolutely. Judgments are a stain on your credit, and you really want to have them taken care of as quickly as possible.
Especially if you have a defense to the claim.
Oh, absolutely.
Okay, we only have a moment left. Any other tips you'd like to offer in terms of winning in small claims court?
The most important tip is to know that you can do it. If you are organized and you have great evidence, you'd be surprised how successful you can be.
And you can also bring a friend or relative for moral support, even if they're not involved in the case.
Absolutely.
And you can always go watch the proceedings. They're open to the public to see what goes on. Go down another night in advance to get a preview of what's going to happen.
I often tell people to go check out the court and see what the cases are like, get a feel for what the environment is like.
And even if you don't have a case, if you want some cheap entertainment, you can go down to the court. But it won't be as dramatic as on TV.
It's never like television.
Okay. I'd like to thank Richard Solomon, who's an attorney, and he's also the author of Winning in the New York Small Claims Court, for being our guest. And you can look for the book at Barnes & Noble and other local bookstores. And he also has a website, smallclaimsbook.com. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. And please join us next week at this same time for another program on Law You Should Know.